Imagine you are a medical provider. You walk into your clinic on a Tuesday morning, you grab your coffee, and a process server just walks up and hands you a massive stack of legal
Oh,
documents.
that is a terrible way to start a Tuesday.
Right, it's a nightmare. Because a patient you've been treating, like for a chronic condition, is actively suing you for malpractice. They're claiming you caused them severe harm. They're coming after your medical license, your livelihood, your, professional reputation.
Yeah, the stakes are incredibly high in that moment.
Exactly. You are furious, you are terrified, and then your receptionist walks in and says, hey, that patient is in exam room 2 for their 9 a.m. appointment.
Wow.
Yeah. Now, I think most people would assume you can just, I don't know, kick them out, right? Like call security, just ban them from the premises entirely.
I mean, human instinct absolutely tells you to do that. But kicking them out is actually the fastest way to add a devastating charge of patient abandonment to that existing malpractice suit.
Wait, really? Even if they are actively suing you?
Oh, absolutely. The underlying logic of medical law operates on, like, an entirely different frequency than basic human instinct. Human instinct tells you to protect yourself, to immediately sever ties with someone trying to destroy you.
Right. Flight or fight.
Exactly. But medical law demands that until a safe, equivalent transition of care is fully arranged, the physical vulnerability of that patient supersedes your personal conflict. So you literally have to walk into exam room 2, look that person in the eye, and provide the exact same standard of care you would provide to your favorite patient.
That is just wow. That profound disconnect between, human instinct and professional obligation is exactly what we are diving into today. You are listening to a deep dive meant to act as your ultimate shortcut to mastering the legal, ethical, and moral frameworks that govern healthcare.
It is a massive topic.
It really is. Whether you are actively prepping for a medical assistant certification exam or you're just, fascinated by the hidden machinery of medicine, we are pulling apart the rule book today. We want to move past the simple memorization of terms and really get into the mechanisms. Like, why do these rules exist? How do they force professionals to act against their own impulses?
Yeah, we are unpacking a really comprehensive framework today. We'll be looking at the friction between personal morals and professional ethics, the severe distinctions between criminal and civil liabilities, especially as they apply to a clinic.
Right.
And, the precise chain reaction required to prove medical malpractice, plus the whole complex web of federal laws and bioethical principles that dictate every single interaction in a healthcare setting.
So to understand how a provider can be legally forced to treat someone suing them, I feel like we have to start at the bedrock.
Yeah.
Because we throw the words legal, ethical, and moral around in everyday conversation like they are synonyms.
Oh, constantly.
Yeah, people say that's illegal or that's unethical or that's immoral, and they just sort of blend together. But in the context of medicine, treating them as synonyms is incredibly dangerous.
Yeah. Blurring those lines leads directly to the loss of a career, or honestly worse. The distinction between the three is the absolute foundation of professional survival. So let's just begin with the law.
Okay, lay it out for us.
The law is not a suggestion. It's a system of societal rules created and enforced by governmental bodies, at the federal, state, and local levels. It is binding.
Right.
It's the concrete framework for judging professional performance. Basically, the law dictates the absolute baseline of what is permitted and what is strictly prohibited, trying to balance public safety with individual rights.
So we were talking about statutes passed by legislatures or common law established by judges through precedent. The law is this, like external force. But then we have ethics. And ethics seems to operate on a slightly different plane, right?
It does. Ethics govern the specific conduct of a specific group. So they are intangible rules, but they're formalized by professional organizations. In healthcare, ethics define what the profession itself collectively believes to be right or wrong behavior.
Okay, so it's tied to the job.
Exactly. It is the standard you agree to uphold when you enter that specific career. You can think of ethics as the collective conscience of the medical profession, and it's designed to protect the integrity of the field and, above all else, the welfare of the patients.
Which leaves morals.
Right. Morals are entirely personal. They are the deeply held principles of right and wrong behavior carried by an individual. They're often shaped by their upbringing, their religion, or, their personal philosophy. Morals are your internal compass.
And this is where the tension lies. Because what happens when your internal compass points in the exact opposite direction of the profession's collective conscience?
That is the ultimate test.
Right. I want to explore a highly specific scenario from our sources that illustrates this collision perfectly. I want to be incredibly clear to you listening. We're looking at this purely as a structural professional dilemma. We are completely impartial here. We are not taking a political, religious, or moral stance on the medical procedure involved. We're just examining the machinery of the rules.
And that impartiality is vital because the scenario itself is designed to evoke a strong emotional response, which honestly is exactly what healthcare workers face in the real world every day.
Exactly. So here is the scenario. A pregnant patient receives an abortion from an OB/GYN in a clinic. The patient explicitly chooses not to tell their partner about the procedure.
Okay.
Now, a medical assistant working in that clinic overhears this information. And this medical assistant has a profound, deeply held moral belief that abortions are wrong. Additionally, they hold a strong moral conviction that marriage requires absolute 100% transparency between partners.
This is getting complicated.
Oh, it gets worse. To escalate the tension, the medical assistant knows this couple socially. They sit in the same queues at the same church every Sunday.
Wow. Okay, so we have a perfect storm of conflicting frameworks here. That medical assistant is carrying a massive psychological burden right now.
Because their personal morals are screaming at them to intervene, right?
Exactly. To inform the partner, to correct what their internal belief system categorizes as a severe moral failure, the impulse to act on that moral conviction is going to be incredibly powerful.
But if they act on it, if they actually go up to that partner at church, they trigger a catastrophic professional collapse.
Oh, an absolute collapse. The mechanism of professional healthcare requires that the medical assistant's personal morals be entirely subordinated to legal and ethical restrictions.
So the personal compass just doesn't matter here.
Professionally, no.
Yeah.
The law, specifically patient confidentiality regulations, strictly prohibits the disclosure of that medical information to anyone without the patient's explicit consent. Furthermore, the Professional Code of Ethics demands respect for patient autonomy and privacy.
Okay, so let's unpack this. The why here is really about systemic trust, isn't it? If patients believe that the personal morals of the person, like taking their blood pressure, might result in their private medical decisions being broadcast to their spouse or their community, they will simply stop seeking medical care.
That's exactly it. The entire healthcare system relies on the absolute guarantee of confidentiality. If that medical assistant approaches the partner at church and reveals the procedure, they haven't just committed a moral crusade. They've committed a severe ethical breach and broken the law.
So what happens to them?
They face immediate termination, civil liability for violating privacy, and potential criminal penalties depending on the jurisdiction. The profession demands that regardless of your personal perspective, you must adapt your actions to align completely with the ethical standards of your organization.
It brings to mind a structural way to visualize this. Like, think of your morals as your own personal compass. You carry it in your pocket. It points to your personal true north.
I like that.
Yeah, and ethics are the navigation rules of the specific ship you're sailing on, the professional guidelines you agreed to follow when you signed on to the crew. And laws. Laws are the ocean's unforgiving physical boundaries. They are the reefs and the shores. You can ignore your compass, you can argue with the captain about the ship's rules, but if you hit the legal bedrock, your ship is going down.
That is a perfect analogy. The ocean does not care about your compass. If you violate the legal boundaries, the consequences are immediate and they are severe.
So let's explore those consequences. Let's look at what happens when a healthcare professional actually hits that legal bedrock. This requires understanding the fundamental divide in our legal system, which is the split between criminal law and civil law. Because, we usually think of crimes as things happening on the street, not in a sterile clinic.
Right, but criminal law deals with actions that are explicitly forbidden by statute because they threaten society as a whole. In criminal law, the government itself acts as the plaintiff. It's the state prosecuting an individual.
So it's not patient versus doctor.
No, it's the state versus the doctor. The focus is on punishment, jail time, severe fines, loss of liberty. And because the state is attempting to take away someone's freedom, the burden of proof is extraordinarily high. The prosecution has to prove guilt beyond a reasonable doubt.
Meaning the jury cannot have, any logical hesitation about the defendant's guilt.
Exactly. Now compare that to civil law, which governs disputes between individuals or organizations. Civil law is not about punishing society's rule breakers with prison. It's about resolving private conflicts and compensating victims for harm.
Okay, so if a clinic accidentally double bills a patient, that is a civil dispute.
Yes. And because liberty is not at stake, only money, The burden of proof is much lower. It relies on what's called a preponderance of the evidence.
Which basically translates to more likely than not, right?
Yeah, pretty much.
Yeah.
If the jury is 51% convinced the clinic made the billing error, the patient wins the civil suit.
But I want to stay on the criminal side for a moment, because the implications for medical professionals are terrifying. Criminal law is split into misdemeanors and felonies. And for an audience familiar with healthcare, we don't need to define what shoplifting is. We need to know how these classifications trap medical workers.
Sure. So misdemeanors are crimes punishable by less than a year in a county or regional jail. In a healthcare setting, a misdemeanor might involve something like petty theft of clinic supplies or perhaps disorderly conduct during a dispute with a colleague.
Okay, relatively minor in the grand scheme.
Right. But felonies are where the career-ending, life-altering consequences reside. Felonies are serious crimes involving intent to cause significant harm or deprive property, and they are punishable by more than a year in state prison or even death.
So let's look at how typical felony categories translate to the medical world. Take murder versus manslaughter. Outside the clinic, we know murder involves premeditation and manslaughter is a reckless accident. How does that map onto, say, a provider prescribing medication?
The defining element separating the two is a legal term called malice aforethought. Murder requires intent.
Okay.
If a doctor, perhaps acting as a so-called angel of death, intentionally administers a lethal dose of a paralytic with the express purpose of ending a patient's life, that is murder. There is clear malice and there is premeditation.
But what if they're just exhausted? Like a nurse is working a 14-hour shift, misreads a chart, and administers a massive overdose of a dangerous narcotic. The patient dies. There was zero intent to kill.
That introduces the concept of involuntary manslaughter. Involuntary manslaughter occurs when a death results from a lawful act performed without proper caution or a reckless action.
So because they didn't mean to do it, it's not murder.
Right. The nurse did not intend to kill the patient. There was no malice, but the recklessness of failing to verify the dosage was so severe, so far below the standard of care that it crosses the line from a simple civil mistake into criminal recklessness. The lack of malice keeps it from being murder, but the extreme negligence makes it a felony.
Wow. We also see this translation with property crimes in our sources. Robbery versus burglary. In the real world, robbery involves holding someone up at gunpoint while burglary is sneaking into an empty house. How does that happen in a medical office? Like, aren't they just the same thing?
They definitely aren't. The critical legal distinction is the presence of the victim and the use of force or intimidation. Robbery is taking property from a person's immediate presence through force or fear.
So, an example.
If an individual enters a pharmacy, threatens the pharmacist with a weapon, and demands narcotics, that is robbery. The victim is present and they are intimidated.
And burglary.
Burglary involves unlawful entry into a structure with the intent to commit a crime, usually theft, but without the victim present. So if a medical assistant uses a key card to enter the clinic at 2 a.m. when the building is entirely empty to steal blank prescription pads or, sample medications from the supply closet, that is burglary. The crime is the unlawful entry itself combined with the criminal intent.
It is so fascinating how the geometry of the crime, like who is in the room, what the intent was, completely changes the legal charge.
It really does.
But as dramatic as criminal charges are, the reality is that the vast majority of legal entanglement for medical workers happens in civil court. Specifically, a branch of civil law called torts.
Yes, torts are civil wrongs. The word itself actually derives from the Latin tortum, meaning twisted or wrong.
Twisted action.
Exactly. A tort occurs when one person's behavior causes injury, damage, or financial loss to another person. And the legal system provides a remedy in the form of monetary damages. Torts are broadly divided into intentional and unintentional acts.
Okay, intentional torts are deliberate. You meant to do the action that caused the harm. We are talking about things like assault, intentionally threatening someone to the point they fear for their safety, or battery, actual unconsented physical contact.
Yeah.
But the one that really stands out in the modern medical landscape is defamation of character.
Defamation is a huge issue now. It involves making false statements that damage someone's reputation. And it splits into two categories based on the medium. Slander is spoken defamation.
Right.
If a medical assistant stands in the clinic break room and loudly, falsely claims a specific doctor is operating under the influence of alcohol, damaging that doctor's standing, That is slander.
And libel is written. I mean,
No.
in the era of online reviews and social media, libel seems like a massive landmine for clinics. Like a disgruntled employee leaving a completely fabricated review about a clinic's sanitary practices on Google is committing an intentional tort.
Yes, the intentionality is the key there. The person knew the statement was false or acted with reckless disregard for the truth. However, while intentional torts do occur in healthcare, the industry is primarily defined by the other category. Unintentional torts. This is the domain of negligence.
Negligence implies a mistake, right? The harm wasn't planned. It was the result of a failure to take proper care. This is the absolute bread and butter of medical law. But how does a jury of laypeople actually determine if a highly trained medical professional made a negligent mistake?
Well, the entire concept hinges on a legal mechanism called the standard of care. In any negligence suit, the plaintiff must prove that the defendant owed them a specific standard of care.
And how is that standard defined?
The standard is defined as what a reasonably competent provider with the same level of training would have done in the exact same circumstances. If a reasonably competent nurse would have checked the patient's allergy chart before administering penicillin and the defendant nurse failed to do so, they breached the standard of care.
Usually, proving that breach requires a parade of expert witnesses.
Yeah.
You have to hire doctors to testify against doctors to explain the standard to the jury. But there is a specific legal doctrine in our sources where the mistake is so bafflingly obvious you don't even need the experts.
Ah, yes. Res ipsa loquitur.
Res ipsa,
Yeah, res ipsa loquitur. The Latin translates directly to the thing speaks for itself. It is a really powerful rule of evidence. It actually shifts the burden of proof.
how so?
Normally, the patient has to prove the doctor was negligent. But under res ipsa loquitur, the nature of the injury is so inherently tied to negligence that the court presumes the doctor messed up, and the doctor now has to prove they weren't negligent.
Okay, the classic example from the text is the surgical sponge. A patient goes in for an appendectomy, recovers, but develops a massive abdominal infection. An X-ray reveals a surgical sponge was left inside their body cavity. You don't need a Harvard medical professor to tell a jury that leaving a sponge inside someone falls below the standard of care.
Exactly. The sponge speaks for itself. It could not possibly be there unless someone on the surgical team failed in their duty. And this specific type of professional negligence, when a highly trained professional fails to meet their industry standard of care, is what we call medical malpractice.
Now, malpractice isn't just a general feeling that something went wrong. It is a highly mechanized legal formula. To win a malpractice suit, a patient has to construct a chain of 6 specific factors. If even one link in that chain breaks, the lawsuit fails entirely.
And that precision is what protects providers from frivolous lawsuits. So let's trace the links. Factor 1. A relationship must exist between the provider and the patient. You cannot be sued for malpractice by a stranger you walked past on the street who happened to be coughing. There must be an established professional connection.
Right. And factor 2. That relationship created a legal duty. Once you accept them as a patient, you are legally bound to protect their health within your scope.
Yes. Factor 3. That duty required adhering to a professional standard of care, which we just discussed. Factor 4. The provider breached that duty by acting negligently or failing to act when required.
Got it.
Factor 5. The patient sustained a resulting injury.
Okay, but it is factor 6 that is the most fascinating and the most fiercely debated in courtrooms.
Yeah.
Causation, the concept of proximate cause.
Causation is the glue of a malpractice claim. The plaintiff must prove that the injury they sustained would not have happened but for the provider's specific breach of duty. The negligence has to be the direct proximate cause of the harm.
Let's test this with a hypothetical to see how it breaks down. Imagine a patient comes in complaining of severe headaches. The doctor performs a cursory exam, completely misses the signs of an operable brain tumor, and tells the patient to just, take some aspirin.
A massive breach of the standard of care?
Absolutely. The doctor completely failed, but then the patient leaves the clinic, steps off the curb, and is instantly struck by a speeding bus and killed.
Oh, wow. Okay.
So the family attempts to sue the doctor for malpractice, pointing to the misdiagnosis of the tumor. The doctor was undeniably negligent in missing it. However, the malpractice claim completely disintegrates at factor 6.
Right, because the doctor's negligence did not cause the patient to be hit by the bus. There is zero causal link between the missed tumor and the actual cause of death. The but-for test fails. The fatal injury would have happened regardless of the doctor's medical error.
So the law requires a perfect alignment of duty, error, and resulting harm. But even when a patient can prove all 6 factors, providers still have defensive shields they can deploy. Let's look at the three major defenses against a malpractice claim.
Well, the most absolute defense is procedural, the statute of limitations. The law does not allow someone to hold the threat of a lawsuit over your head forever. State laws establish a strict time limit, often 2 or 3 years, within which a patient must file a claim after an injury occurs or is discovered.
So if they file on day 1 of year 4, the judge throws it out, regardless of how guilty the provider is.
Yes, the time frame is rigid, though exceptions do exist, particularly for minors. Now, the second major defense is contributory or comparative negligence. This argues that the patient themselves shares the blame for the bad outcome.
Wait, how does a patient contribute to their own medical malpractice?
Imagine a physician correctly diagnoses a severe infection and prescribes a strict course of antibiotics, explicitly warning the patient of the dangers of noncompliance. But the patient decides to stop taking the medication after 2 days because they feel slightly better.
Which happens all the time.
All the time. Then the infection aggressively returns, leading to, say, the loss of a limb. The patient sues. The defense will argue that the patient's own negligence ignoring medical advice was the proximate cause of the amputation, which significantly reduces or entirely eliminates the provider's liability.
Okay, the third defense is the emergency defense, which is intertwined with Good Samaritan laws. This is what happens when medical professionals try to help outside of their normal clinical environment, right?
Yes. The law recognizes that chaotic emergencies do not allow for sterile environments, full medical histories, or considered standard of care practices. If an off-duty nurse witnesses a car crash, pulls a victim from the wreckage, and begins CPR, they might accidentally crack the victim's ribs.
Right, which is a common complication of CPR.
Exactly. Good Samaritan laws generally immunize individuals acting in good faith during an emergency from civil liability for those unintentional injuries.
There is a catch, though, right? Gross negligence.
Yes, the immunity is not absolute. If the intervention crosses the line into gross, reckless negligence, for example, if that same nurse attempts a complex roadside tracheotomy with a dirty pocket knife when simple CPR was all that was required, the Good Samaritan shield evaporates. The intervention must be reasonable given the circumstances.
Even with these defenses, the sheer volume of potential liability requires a massive financial safety net. I mean, a single malpractice judgment can run into the millions.
Which is why we have comprehensive risk management and liability insurance. Risk management is the systematic process of identifying vulnerabilities in a clinic's procedures, from how floors are mopped to how lab results are tracked, and implementing protocols to prevent errors before they occur. It's proactive defense.
But when the proactive defense fails, you need insurance. And there is a critical distinction between personal liability insurance and professional malpractice insurance.
Right. Personal liability might cover someone slipping on the icy steps of your private home. But professional malpractice insurance is specifically designed to cover the financial damages and legal defense costs arising from errors and omissions in the delivery of medical care. It is a vital shield.
But it doesn't cover everything.
No. A crucial caveat exists. Malpractice insurance does not cover criminal acts. If a provider is found guilty of intentionally defrauding Medicare or sexually assaulting a patient, the insurance policy will not pay the legal fees or judgments.
There is also an interesting note for medical assistants, specifically in our sources. We usually assume the doctor's insurance covers the whole staff.
It's true that employers typically hold policies covering their staff under the legal doctrine of respondet superior, meaning the master must answer for the servant. If a medical assistant makes a negligent error, the employer can be sued. But the medical assistant can also be sued individually. Because the employer's insurance is primarily designed to protect the employer's assets, professional organizations strongly recommend medical assistants carry their own personal professional liability insurance to ensure their individual interests are fully defended in court.
Better safe than sorry. So we keep talking about this relationship between the provider and the patient, the relationship that triggers all these duties and liabilities. It's easy to think of it as just a therapeutic bond. But structurally, legally, the provider-patient relationship is actually a binding contract.
It is a contract in the truest legal sense, requiring 4 precise elements to be valid. First, the offer. The provider expresses a willingness to treat a specific patient population, perhaps by opening a specialized clinic.
Second, acceptance. The patient accepts the offer by scheduling an appointment, walking into the clinic, and submitting to an examination.
Third is consideration. In contract law, consideration means an exchange of value. The provider exchanges their medical expertise and time, and the patient exchanges monetary payment or an agreement to bill their insurance. Without this exchange of value, a formal contract is very difficult to prove.
And fourth is obligation. Once the value is exchanged, the provider is legally obligated to provide the standard of care, and the patient is obligated to compensate the provider. But here is where the legal machinery gets complicated. Not every human being is legally allowed to enter into a contract. You must have the capacity to contract.
Right. Capacity refers to the legal competence to understand the nature and consequences of the agreement. Generally, to possess capacity, an individual must have reached the age of majority in their state, usually 18. Furthermore, they must be free of legal disabilities.
And when we say legal disability in this context, we aren't talking about a physical wheelchair. We are talking about mental state.
Exactly. A person suffering from severe dementia, or someone who is profoundly intoxicated by drugs or alcohol at the moment they enter the clinic, lacks the legal capacity to comprehend a medical contract. They cannot legally consent to complex surgery, nor can they legally refuse it. The law requires a designated legal representative to step in and make those contractual decisions on their behalf.
The area of capacity that requires the most navigation, though, is treating minors. The default rule is that minors cannot consent. But the exceptions to this rule are fascinating because they reveal how the law bends to accommodate practical reality and public health.
The law recognizes two major exceptions: emancipated minors and mature minors. An emancipated minor is an individual under the age of majority who has been legally granted adult status by a court. They are entirely self-supporting, perhaps married, or serving in the armed forces. For all medical and contractual purposes, they hold the exact same capacity as an adult. They can consent to anything.
But the mature minor doctrine is entirely different. It's a targeted carve-out.
Yes. Mature minor laws are specific to state jurisdictions. They allow minors who demonstrate sufficient maturity to consent to specific, highly sensitive medical treatments without requiring parental notification or permission.
Why do they do that?
The legal mechanism here is driven by public health outcomes. States recognize that if a 16-year-old is required to tell their parents they need treatment for a sexually transmitted infection or substance abuse counseling or mental health intervention, that teenager will likely just avoid seeking treatment entirely out of fear.
So the law suspends the requirement for parental consent to ensure the minor actually gets the care they need. It prioritizes the actual health outcome over the parent's right to know.
It's a pragmatic legal compromise designed to protect vulnerable youth.
Okay, so assuming we have a patient with the legal capacity to contract, how do they actually pull the trigger? How do they agree to the treatment? Medical consent comes in three distinct forms.
The most straightforward is express consent. The provider proposes a treatment and the patient explicitly agrees. This can be verbal, like saying, "Yes, go ahead and draw my blood," or written through signing a consent form. The intention is clear and articulated.
But what if they can't articulate it? What if they are unconscious?
That introduces implied consent. This is most common in emergency medicine. If a patient is rushed into the trauma bay unresponsive with a severed artery, they cannot give express consent. However, the law implies that any reasonable person in that situation would consent to life-saving measures. Therefore, the provider is legally protected in initiating treatment without a signature.
There is a massive boundary line here, though. Implied consent assumes the patient would want to live. But what if we know they don't want the treatment? What if they arrive unconscious but they are wearing a legally binding do not resuscitate medical alert bracelet, or their chart clearly indicates they refuse blood transfusions for religious reasons?
Implied consent can never, under any circumstances, override explicit, documented rejection of care. If the provider ignores the DNR bracelet and resuscitates the patient, using implied consent as an excuse, they have committed medical battery. They have violated the patient's bodily autonomy.
Which brings us to the gold standard, informed consent. This isn't just about getting a signature. It is an educational process.
Absolutely. Informed consent is mandatory for any complex or invasive procedure. It requires the provider to thoroughly explain the diagnosis, the nature and purpose of the proposed treatment, the realistic benefits, the potential risks and complications, and crucially, any alternative treatments available, including the risk of doing nothing at all. The patient must truly understand the landscape of their choices before their signature is considered legally valid.
Because at the core of all this is the Patient Bill of Rights. A competent patient has the absolute right to dictate what happens to their body. They have the right to consent, and they have the equal corresponding right to completely refuse care, even if that refusal will directly result in their death. The provider can advise against it, but they cannot force it.
It is the ultimate expression of autonomy within the medical contract.
So the contract binds the provider and the patient together, but contracts end. How does a provider legally terminate this relationship? We established in our opening hook that you can't just lock the door on a patient who is suing you. There is a minefield between proper termination and illegal abandonment.
The law provides 4 acceptable pathways for proper termination. The first is mutual consent. The provider and patient agree the relationship is no longer beneficial and part ways amicably. The second is patient dismissal. The patient retains the absolute right to fire their doctor at any time, for any reason, and seek care elsewhere.
Third is a change in circumstance. Like, the patient was seeing an orthopedic surgeon for a broken arm. The bone is healed, the cast is off, the physical therapy is complete. The medical need has resolved, so the contract naturally expires.
Right. And the fourth pathway is provider withdrawal, and this is where the strict procedural rules apply. A provider has the right to drop a patient. Perhaps the patient is repeatedly non-compliant, abusive to staff, or constantly failing to pay their bills. However, the provider must execute this withdrawal meticulously.
What are the steps?
They must send formal written notification to the patient, usually via certified mail, to prove receipt. Furthermore, they must provide the patient with a reasonable window of time, often 30 days, to secure a new physician. During that 30-day window, the original provider remains legally obligated to provide emergency care and standard treatments.
If they skip those steps, if they just tell the patient, don't come back and hang up the phone.
That constitutes abandonment. Abandonment is the unilateral severance of the professional relationship by the provider without adequate notice, at a time when the patient still requires medical attention. It is a severe breach of duty that leaves the provider highly vulnerable to malpractice litigation and disciplinary action by medical boards.
And there are situations where the law compels a provider to continue care, completely forbidding them from withdrawing.
Yes, the law identifies specific scenarios where the danger of abandonment is so high that withdrawal is prohibited. For example, if a patient is suffering from advanced HIV and requires continuous, complex pharmacological management, dropping them abruptly could cause an immediate, catastrophic health decline. The provider must maintain care until a specialized replacement is secured.
Which loops us perfectly back to our opening scenario, the patient suing you.
Right. What's fascinating here is that the law dictates that a malpractice lawsuit does not instantly sever the medical contract. The tension is extreme. You are treating someone attempting to bankrupt you. But the legal framework determines that the physical safety of the patient during a vulnerable medical moment outweighs the provider's psychological discomfort. Until the formal withdrawal process is complete and a new doctor is found, you cannot abandon them.
It is a stark reminder of the unique burden placed on healthcare professionals. Now, part of that burden involves keeping patient secrets. We know confidentiality is sacred. But the law also identifies moments when keeping a secret makes you complicit in a crime. This is the realm of privileged communication and mandatory reporting.
The baseline rule is privileged communication. A patient's medical information is their property. A provider or medical assistant is legally and ethically bound to disclose that information only to the patient themselves or to other providers directly involved in their active care.
Let's look at a daily friction point for this. A patient is in the hospital. Their adult daughter calls the nursing station. The daughter is terrified, crying, asking if her father's biopsy results came back. She means well. She loves him.
It is a heart-wrenching situation, but the legal mechanism is entirely unyielding. Unless the patient has explicitly signed a release form authorizing the staff to share medical information with that specific daughter, confirming even the simplest detail about the biopsy is a violation of privileged communication. The emotional intent of the family member does not override the legal right to privacy of the patient. The only external entity that can shatter that privacy without patient consent is a direct court order.
Except when the law itself mandates the shattering of privacy. Mandatory reporting laws are the state stepping in and saying, in these specific instances, the danger to the vulnerable or the public is so massive that your duty to confidentiality is revoked.
Exactly. The most critical area of mandatory reporting involves abuse, neglect, and exploitation. The state forces healthcare workers to act as an early warning system because victims are often too terrified or incapacitated to report the crimes themselves. The scope of abuse is broad. It includes physical abuse, the intentional use of force causing injury. It includes sexual abuse.
It also includes neglect, which is more insidious. It's the failure of a caregiver to provide basic physical, emotional, or social needs, like an elderly patient arriving with severe bed sores and malnutrition because their caregiver is ignoring them. That is neglect.
There is also emotional abuse involving systematic humiliation or intimidation to exert control, and financial abuse, which is increasingly common among the elderly. This involves the improper or unauthorized use of an older adult's resources, like convincing a patient with dementia to sign over the deed to their house.
So who are providers mandated to report?
Universally across all states, healthcare workers are mandated reporters for suspected child abuse. Furthermore, they are mandated to report suspected elder abuse, generally defined as harm or neglect to individuals aged 60 and older. Many jurisdictions also mandate the reporting of intimate partner violence, recognizing the escalating lethality of those situations.
Now, a medical assistant listening might be thinking about the liability. What if I see bruising on an elderly patient, I suspect the son is abusing them, I report it to Adult Protective Services, and an investigation proves I was wrong? Can that son sue me for defamation? Can the patient sue me for breaking confidentiality?
It is a crucial question. The law recognizes that if providers fear being sued for making a mistake, they will stop reporting abuse and vulnerable people will die. Therefore, the law provides robust legal immunity. As long as the report is made in good faith, meaning they genuinely suspected abuse based on their professional observation rather than acting out of malice to harass a family, they are entirely shielded from civil liability and confidentiality breaches. The state protects the reporter to protect the victim.
Abuse isn't the only trigger for mandatory reporting. The law also targets public health threats.
Right. Providers must report diagnoses of highly communicable diseases such as syphilis, tuberculosis, or certain viral outbreaks to the local public health department. The state needs to track and contain epidemics. They must report vital statistics, ensuring all births and deaths are legally recorded. And crucially, they must report wounds of violence to law enforcement.
If a patient walks into an urgent care with a gunshot wound or a severe knife laceration, the provider cannot keep that secret. They must alert the police because a violent crime has clearly occurred in the community.
Absolutely. The reporting of misconduct also extends inward toward the medical facility itself. Medical assistants must navigate internal reporting chains. If they witness absolute criminal conduct by a colleague, such as a nurse diverting fentanyl for personal use, that requires immediate notification of law enforcement. However, if they witness ethical or professional misconduct by a provider, perhaps a doctor consistently cutting corners on sterile technique, that is reported up the administrative chain of command to the practice manager or compliance officer.
All of these reporting mandates, the privacy walls, the liability shields, they're all woven into a massive, overarching web of federal legislation. Healthcare is one of the most heavily regulated industries on Earth. Let's decode the federal alphabet soup that dictates the boundaries of a medical assistant's daily life.
We must begin with MPA, the Health Insurance Portability and Accountability Act. While universally known for privacy, MPA's original intent was dual-pronged. Title I was designed to ensure that workers who lost or changed jobs could maintain their health insurance coverage, often executed through the mechanisms of COBRA.
It is Title II that revolutionized the clinic, though, the privacy rule. It established the first truly strict national standards for the protection of confidential health information, dictating exactly how physical and digital records must be secured and severely punishing unauthorized disclosure.
Following a HIPAA and massive impact is the ACA, the Affordable Care Act. Among its sweeping reforms to insurance markets and pre-existing conditions, a vital provision for younger populations is the mandate allowing adult children to remain on their parents' health insurance plans until the age of 26, significantly reducing the uninsured rate among young adults.
Then we have the ADTI, the Americans with Disabilities Act, Amendments Act. This law fundamentally broadened the legal definition of disability, ensuring that more individuals receive robust civil rights protections. In a clinical setting, this means aggressive requirements for physical accessibility, braille signage, and equal opportunity for employment.
Right. Then there is the Uniform Anatomical Gift Act, or UAGA, which is the legal framework governing organ donation. It standardizes the processes by which individuals can legally consent to donate their organs or tissues upon death, facilitating the massive logistical network of transplant medicine.
But one of the most fascinating federal laws is GINA, the Genetic Information Non-Discrimination Act of 2008. Before GINA, if you took a genetic test to see if you carried the BRCA gene for breast cancer and the result was positive, your health insurance company could legally drop you, or your employer could fire you, based on the fear that you might get sick in the future.
It was a chilling reality that prevented thousands from seeking life-saving genetic screening. GINA explicitly outlawed this. It prohibited employers from using genetic information in hiring, firing, or promotion decisions, and it barred health insurers from using genetics to deny coverage or calculate premiums. It protected the patient's biological blueprint.
Another major federal safeguard is the Stark Law. This targets the financial motivations of doctors. So, a doctor can't refer you to an MRI clinic they secretly own. It's about keeping the financial incentives out of the treatment plan.
Exactly. The Stark Law, formerly the Ethics in Patient Referrals Act, is designed to prevent deeply entrenched conflicts of interest. It explicitly bans self-referral. If a physician holds a financial stake in a separate medical facility, say they are a silent partner in a standalone MRI imaging center, they are legally prohibited from referring their Medicare or Medicaid patients to that specific center.
Because if they were allowed to, every single patient who walked in with a mild headache would suddenly be told they urgently need a highly expensive MRI at that specific clinic. A doctor's advice must be dictated entirely by the clinical necessity of the patient, completely isolated from the doctor's personal financial gain.
It keeps the profit motive out of the diagnostic process. And finally, a more recent federal milestone is the 21st Century Cures Act. While it aimed to accelerate medical product development, its profound impact on the clinic floor was the information blocking rule. It mandated that healthcare providers give patients free, instant electronic access to their own medical records, test results, and clinical notes, primarily through secure patient portals on smartphones. It radically democratized medical data.
All of these federal laws operate under the Supremacy Clause of the United States Constitution. If a state passes a law attempting to weaken IPO privacy protections, the federal IPO law automatically overrides it. Federal law is supreme, and navigating this massive legal web is entirely dependent on a medical assistant staying within their scope of practice.
Scope of practice is the ultimate legal boundary line. It defines the specific procedures, actions, and processes that a healthcare practitioner is permitted to undertake in keeping with the terms of their professional license or certification. For a medical assistant, the scope is governed by state law, meaning a medical assistant in New York may have slightly different authorized duties than one in Florida, and by the guidelines of their credentialing body.
But the universal rule across all states is delegation and supervision. Medical assistants perform delegated clinical and administrative duties under the direct supervision of a physician or licensed provider.
And the absolute impenetrable wall of that scope is that a medical assistant's duties shall not constitute the practice of medicine. A medical assistant cannot independently diagnose a patient's condition, they cannot independently interpret test results, and they absolutely cannot prescribe medication.
The scope of practice is a safe harbor. If a medical assistant notices a rash on a patient, and they have seen that exact rash 1,000 times, and they know exactly what cream cures it, they might feel a strong impulse to just tell the patient what it is. If they do that, they have stepped outside their scope. They have just practiced medicine without a license. They lose their safe harbor. If the cream causes a severe allergic reaction, the medical assistant is entirely personally liable for negligence and faces criminal charges.
The strict adherence to the scope of practice protects the patient from unqualified medical decisions and protects the medical assistant from devastating legal ruin.
The law is very good at telling us what we are absolutely forbidden to do. But as we've seen, healthcare isn't a series of easy binary choices. It is a world of gray areas. This brings us to the highest level of our framework, bioethics. Bioethics is the application of ethical principles to the fields of medicine and biology, and it is built on 4 massive foundational pillars.
The first pillar is autonomy. This is the recognition that every patient has an intrinsic, fundamental right to make decisions regarding their own body and their own health care. It is the rejection of medical paternalism, where the doctor decides what is best. Autonomy demands informed consent and respects the right of refusal.
The second pillar is beneficence. This is the active duty of the provider to act in the best interest of the patient, to do good, to provide treatments that heal and comfort.
The third is non-maleficence, familiar to many as, first, do no harm. It is the dual obligation to avoid inflicting intentional harm, and equally important, to avoid causing harm through inaction or negligence.
And the fourth is distributive justice. This is the macro-level ethical dilemma. How does a society or hospital system allocate limited healthcare resources fairly across the population?
On paper, these 4 principles seem perfectly harmonious. In the reality of a trauma center or an intensive care unit, they collide violently. The most profound ethical dilemmas occur when one bioethical principle demands an action that directly violates another.
Let's look at the classic clash between autonomy and beneficence. A patient is brought into the ER with severe internal bleeding. They urgently need a blood transfusion to survive. The doctor is driven by beneficence. They possess the tools and the duty to save the patient's life. But the patient is a devout Jehovah's Witness, and they explicitly, comprehensively refuse the blood transfusion based on their religious beliefs.
The doctor knows that without the blood, the patient will die. Beneficence screams to give the blood. But autonomy dictates that the patient's decision must be respected, even if the outcome is fatal. In modern medical ethics, the autonomy of a competent adult almost universally overrides the provider's desire to enact beneficence. The doctor must stand down. The psychological toll of that ethical restraint on the provider is immense.
And we see distributive justice creating nightmares during crises. During a severe pandemic, if a hospital only has one available mechanical ventilator, but 3 patients are suffocating and need it to survive, who gets it? Do you give it to the youngest patient who has more years to live? Do you give it to the sickest patient who needs it most urgently? Do you give it to the healthcare worker who contracted the disease, saving others?
There is no mathematically perfect answer. That is why they're called ethical dilemmas. There are other perpetual arenas of bioethical tension as well. The complex moral and legal status of abortion, the implications of artificial insemination and genetic selection, the intensely debated boundaries of euthanasia and physician-assisted suicide, and the severe allocation metrics of organ transplantation.
Because an individual healthcare worker cannot be expected to solve these philosophical nightmares alone every time they clock in, the profession relies on professional codes of ethics. These are the rule books we talked about at the very beginning, the ship's navigation rules.
Various credentialing organizations publish strict codes. The AAMA, the American Association of Medical Assistants, dictates a code emphasizing rendering service with full respect for the dignity of humanity, respecting confidential information, and upholding the honor of the profession.
The AMT, the American Medical Technologist, focuses on performing duties competently, with absolute integrity and a dedication to continuous learning.
The NHA, the National Health Career Association, highlights professionalism in acting as a steadfast advocate for the patient, while the AAPC, representing professional coders, requires a commitment to highly ethical coding practices, strictly avoiding any manipulation of data that could result in fraudulent billing.
And of course, the AMA, the American Medical Association, provides the comprehensive code of medical ethics for physicians, setting the standard for the entire industry. All of these codes serve as an anchor. When the laws are confusing, when personal morals are conflicted, when the bioethical principles are clashing, the professional code dictates the path forward.
It requires a profound level of discipline. It brings us back to the central thesis of our discussion. Regardless of your personal perspective, your religious background, or your internal compass, the moment you enter the clinical environment, you must adapt your behavior to align entirely with the ethical standards of your profession and the strict boundaries of the law.
Your personal morals belong to you, but the patient belongs to the profession. We have navigated an incredible labyrinth of information today. We started with the jarring realization that you cannot simply banish a patient who is suing you, uncovering the deep legal requirement to prevent abandonment. We drew the hard lines separating the government's laws, the profession's ethics, and your own personal morals, exploring the physiological stress of holding a secret you desperately want to tell.
We examine the machinery of the legal system, translating the malice of criminal felonies like manslaughter and burglary into the context of the clinic, and dissecting the civil world of torts. We broke down the 6 unforgiving links in the chain of medical malpractice, exploring the strict requirements of proximate cause and the vital defenses that protect providers from ruin.
We decoded the doctor-patient relationship as a binding legal contract, mapping the nuances of who actually has the capacity to consent, especially when dealing with emancipated and mature minors. We walked the tightrope between proper termination of care and the criminal act of abandonment. We explored the heavy burden of mandatory reporting, how the state forces providers to break confidentiality to protect the abused, while shielding those providers from liability.
We traced the massive web of federal legislation from the privacy walls of HIPAA to the anti-corruption mandates of the Stark Law. We established the scope of practice as the ultimate legal safe harbor. And finally, we confronted the towering, often conflicting pillars of bioethics: autonomy, beneficence, non-maleficence, and distributive justice.
It is an awe-inspiring amount of pressure placed on the shoulders of medical assistants, nurses, and doctors. They must balance these massive, invisible forces during every single patient interaction. But as we close out this deep dive, I want to look forward. We mentioned the 21st Century Cures Act forcing medical records onto patient smartphones, increasing transparency. Where does this legal machinery go next?
The next frontier will fundamentally challenge everything we discussed today regarding the standard of care. Consider the explosive integration of artificial intelligence in diagnostics. Currently, a doctor uses their training to diagnose a disease. But what happens in 5 years when an AI diagnostic tool is statistically proven to be more accurate than a human doctor? If a physician relies solely on their own judgment, misses a subtle tumor, and the patient dies, will that doctor be found legally negligent for failing to consult the AI? Will consulting the algorithm become the new legally mandated standard of care? The law is not a static text. It is a living, evolving mechanism that is forced to adapt to the bleeding edge of medical science.
That is a brilliant, slightly terrifying thought to leave on. The rules of the sea are going to keep changing as the technology changes. Thank you for joining us on this deep dive. We hope this exploration has proven to you that true expertise isn't just about memorizing a checklist for a certification exam. True expertise is understanding the why, the profound, complex, and deeply human reasons those rules exist in the first place. Until next time, keep questioning the frameworks around you.